All right, welcome everyone to What Small Businesses Need to Know when Considering Bankruptcy. We have David Berman. He's a mentor for the Boston chapter, and he will be going through a lot of information that will be very helpful to you in deciding what next steps or things to think about as you move through this period. As we get going, though, I want to talk about SCORE in case you are not familiar with SCORE. Our main goal is to share information with the small business community. We do that in a couple of different ways. One is through information on our website, score.org. You're going to find templates to download, articles to read, videos to watch, lots of great information. I strongly encourage you to take a look through there if you haven't been. The other is through our webinars and workshops. Most are online. We do have a few in person on occasion, but we offer the workshops and webinars quite frequently, and they can be found through our newsletter or on our website as well. I think the most important way we share information, though, is through our mentorship program. Our mentors are volunteers. They want to share what they've learned and the skills that they have acquired with you. We work with folks that are at all stages of the game, whether you're in the planning phase or trying to decide if you should own a business, or if you already have a business, or you're ready to close your business. So I strongly encourage you to reach out to a mentor if you don't already have one. Beginning session will be wanting to learn about what your goals and challenges are and helping you come up with a plan to reach those goals and to overcome those challenges. Our mentors do work as a team. Even if you're meeting with one person, they will bring in others as needed to make sure you get all the information that you need to be successful. So getting a mentor is very easy. Just go to the score.org website. There's a blue box that you can enter your zip code, and that will match you to the chapter that's nearest you. We'll then ask you a couple quick questions, and we'll use that information to recommend a mentor to help you along the way. We are recording today, and the recording will be posted in the next 24 to 48 hours. You can go to the score.org/Boston website. On the blue bar, as per this graphic, there's a local workshop tab, and then previously recorded is where you'll find it. We are going to go ahead. We don't have a super large crowd today, so we're going to go ahead and just use chat to communicate with each other. If you do put it in a question into Q&A, that's not a problem. I'll find it. But I will try and reach as many questions as we possibly can if you should have any along the way. I'm going to go ahead and pull this down, and I'm going to go ahead and turn things over to David.
Thank you. Let me just get my screen up here so we can all follow along. There we go. Welcome, everybody. Bankruptcy and insolvency is a very complicated issue. If you're in this situation, you should be getting some legal or financial assistance to help you. So I'm just going to give you a broad outline of some of the things that you can think about as you move through the process. Now, the first thing I'd say before anything about bankruptcy is not a first alternative. It should be a last alternative because it's going to be costly. You run the chance of losing control either to the judge or to the creditors. There are reasons to file bankruptcy, but if you can work it out of court, that is usually a more favorable approach at the outset. Now, before you file bankruptcy, though, you have to do a lot of work. It's not just filing a form with the court saying you're bankrupt. We're focusing here on a Chapter 11 reorganization. There are other bankruptcy chapters, Chapter 13, which would be for an individual, as opposed to Chapter 11, which is really a business reorganization. There's Chapter 7, which you just filed to liquidate your business. We can touch on those a little bit, but the focus here is going to be on a business business bankruptcy. So if you're going into bankruptcy, one thing the courts want to know to keep you alive as a business is, you know, putting aside the problems that led you to bankruptcy, can you, basically break even from a cash flow perspective? So you need to engage professionals, both from the legal end and presumably financial advisors that can help you make your plan for operating in a bankruptcy and ultimately coming out of the bankruptcy. So, you'll need to prepare cash flow with them. And when I say reflecting a bankruptcy impact, in bankruptcy, you don't have to pay whatever you owed previously. So, for example, let's assume that you're 3 months in arrears with your landlord. In bankruptcy, you just have to pay the landlord currently. The 3 months in arrears will be dealt with in your plan to come out of bankruptcy. Uh, similarly, if you owe a vendor $10,000, you don't have to pay that $10,000. That doesn't have to be in your plan for operations in a bankruptcy. Again, that will be dealt with in your plan to come out. Um, a lot of clients need financing when they file bankruptcy, and you know you should be talking to lenders in advance, telling them that you're going to be filing bankruptcy or you're thinking of filing bankruptcy, and will they provide financing for you in the bankruptcy. We'll talk more about the financing later, but you need to do this work because lenders take time to come up and say, I'll do it, and then to draft the documentation that you'll need in order to reflect the bankruptcy. Um, Vendors, that's a case by case question. If you have a key vendor who's supplying a lot of your parts, you may want to keep them abreast of what's going on. Uh, uh, you don't, and you'll do that closer to the filing date because you don't want a vendor to shut you off or require, cash before delivery or something. Uh, because you're telling them you're going to file bankruptcy in a month, you want to try to keep the source coming. Uh, Employees get very nervous when they hear bankruptcy. What they hear is, I'm going to lose my job. So your business is probably as good as your employees. So you want to give them comfort at time. Once again, not the first day you're thinking about it, but you want to give them comfort. And there are ways you can give them comfort financially as well in a bankruptcy. Um, Utilities, once again, in a bankruptcy, you're going to have to make arrangements with the utilities. So you should be talking to them because you don't want them to turn off your lights because they're not getting paid, and there are rules for that as well. Um, you want to think about your landlord. As I said, if you're in arrears with a landlord, you can deal with that in a bankruptcy, but what you can't deal with is if you're in arrears and the landlord has terminated the lease. So you need to keep abreast of what's happening with the landlord. If he sends you a notice, a default notice that he's going to terminate the lease, that may expedite the timing of your filing. And the timing of the filing can be important. I used to be involved with a lot of cases with retailers. And when did they like to file? They like to file in November or December. And why did they file then? Because they had a lot of cash from the holiday season. And so they had cash to live on in addition to the financing, as opposed to filing in the summer months when they may not have had the cash and may not have had the inventory. Um, your attorney will help you prepare schedules, which are really a list of your assets and liabilities, and statements of affairs, which are questions about your business and who you've paid and where you stand with taxes and so on and so forth. Um, First day motions we'll talk about, but when you file bankruptcy, there are many things that you can't do without court approval. So, for instance, if you file bankruptcy today and you have employees who haven't been paid uh, for working Monday through Wednesday of this week, technically you only can pay them for work they do after the bankruptcy. So you want to file a motion with the court saying, I want authority to pay them what they're owed for earlier this week. Similarly, if you have a key vendor, um, some courts sometimes allow you to pay critical vendors uh, because technically, if it's money owed before you file the bankruptcy, they have to wait until they see what your plan is. So there are lots of first day motions you have to file to get the court to allow you to pay your attorneys, to pay your accountants, so on and so forth. So all of this work, as you can see, it can be very time consuming. And so it's not like a bankruptcy. You wake up this morning and say, oh God, my business is in trouble. I want to file bankruptcy Monday morning. You've got a lot of work to do with your professionals and getting the right professionals who are familiar with the bankruptcy process. Assuming you get through that and and you then want to move on from there, we then get into what happens in the bankruptcy. First of all, the bankruptcy will stop basically all lawsuits against you. So if I'm suing you for back rent, I can't pursue that any further unless I get a court authorization. If I'm a vendor pursuing you for overdue payments, I can't pursue that unless I get court authorization. Basically, it freezes everything that's going on. It will not freeze criminal actions. So if somebody is uh, pursuing you in a state authority or federal authority on the basis that you were violating certain laws, uh, that can continue. But anything civilly is stayed and can't be pursued unless they get an order for the court. They can get an order for the court if they can show cause, which is a good reason, which can be things such as, this company is not going to turn around, or, uh, whatever they can come up with good cause. If they have if somebody financed a piece of equipment, like say a corporate vehicle, and the vehicle isn't worth what the debt is, and they can prove that you don't need that car to be able to reorganize your company, then the court could say to them, listen, there's nothing in the car for the company, you don't need it, and there's no value in it, so we're going to let the creditor come in and repossess it. And if you're a real estate company and you only have one asset, you own one apartment building, and the mortgage holder can come in and ask the court to let them foreclose unless you continue to pay interest at the non-default rate and you file a reasonable plan of reorganization within 90 days. So that's something that they'd have to wait 90 days to do. But if you're just sitting on the real estate and not paying them interest, the court could let them come in and foreclose. It's important to note that this stops everything, doesn't apply to personal guarantees. You may have a lease with your corporation. The landlord's required you to personal guarantee. The landlord can still sue you on the personal guarantee, even though it can't go after the corporation. Similarly, a lot of bank loans are guaranteed. The bank can come after you on your personal guarantee. Uh, there are situations in which the court will also stay the enforcement of the guarantee in the bankruptcy, but those are factually driven, and you shouldn't count on that. But you should be aware that if you sign a personal guarantee, even if your company's in bankruptcy, the creditor can continue to pursue you. We talked about the first day orders before. We talked about pre-petition employees and their wages. We talked about maintaining bank accounts. Technically, the day you file bankruptcy, any checks that you have outstanding that dated prior to the bankruptcy, the bank bounces. Um, and technically, you're supposed to open a new bank account. So if I have an account for my ABC Corporation or Bank of America, I am supposed to open a new account that says ABC Corporation debtor in possession, a separate account that would just include receipts received after you filed bankruptcy and payments for debts incurred after the bankruptcy. Sometimes, depending on the size of your company, this is a real pain in the neck. So you go to the court and say, listen, I have 12 different bank accounts across Massachusetts. This is a pain. Can I just maintain my bank accounts? And the court will sometimes allow you to do so. That does not allow the payment on the checks that were written before you filed the bankruptcy, but it saves you having to open up all new accounts elsewhere. Um, Another thing that you like to ask the court is, once again, if you owe taxes, you're an employer, you have withholding taxes, Social Security taxes you've withheld from old employees' pay, uh, um, you know, those you want to pay, just like you want to pay the employees their wages. But you can't do it unless the court allows you to pay the pre-petition taxes. So if you have withholding taxes, they're due on May 1st, you'd have to go to the court if you file today and say, I'd like to pay the withholding taxes I've taken from the employee's pay as of May 1st. And you'd have to get allowance from the court for that. So you can see the recurring theme is when you're in a bankruptcy, you don't have complete discretion. You can ask for it, but you need court approval. And creditors may have a say on whether they want to allow that. A lot of businesses offer gift cards, whether it be a restaurant or a retail business. Technically, that is a debt incurred prior to the filing of the bankruptcy. So if I have a gift card at an Italian restaurant and I want to come in and use it after they file bankruptcy, they can't honor it because they're basically honoring something that they incurred before filing the bankruptcy. So you need to go to the court and ask them that you be able to honor gift cards. And the court may put restrictions on it, like you can honor them for 30 days or whatever. But that's something else you'll need to go to the court for. Also, if you have a lender who has a lien on your assets, you cannot just use the cash that's in your bank account is basically the lender's collateral. So you have to go to the court and say, I want to use the cash, or you go to the court and say, I want to get financing on an interim basis. Interim meaning that you needed emergency on day one, but people are going to be able to come in at a later date and object or to the financing. And a lot of these orders you're getting on the first day, the creditors will not have formed yet a committee or a group to come in. So a lot of these motions may be done without opposition, but the court will set another date where people can come in and oppose it or offer solutions other than what you want. But the use of cash collateral or interim financing, if I have a lien on your bank account and you've got $10,000 in the bank account, and the court just lets you use the $10,000, I've lost $10,000 of collateral. So you're going to have to find some way to agree how to replace that, either by giving a lien on receivables, on other assets that don't have liens on them, or somehow so that the purpose of that is that the existing person who has a claim on that cash is not detrimented, so that if they liquidated you today, they'd get the $10,000. If in 6 months they liquidate you, they should still have the ability to get that $10,000 somehow. And so, this is a big negotiation with the lenders in terms of what you can do to protect their position. And similarly, when we're talking about financing, a lender in a bankruptcy probably does not want to give you loans on an unsecured basis. It would want a lien. You can give it a lien on assets that aren't encumbered. So, for example, let's assume that you own your building and you have a mortgage on the building, but you don't have a mortgage on your inventory and equipment. You could give the lender a lien on the inventory and equipment to protect its loans in the bankruptcy. On the other hand, there are processes which are somewhat complicated, in which you could give the lender a first lien on the real estate if your inventory and equipment and other assets were already liened, and so you jump the existing mortgage holder, but you'd have to show that the mortgage holder isn't going to be harmed by this. So that, if the mortgage is for $50,000 and your property is worth $200,000 and you want to borrow $75,000, jumping the mortgage holder shouldn't hurt him because there's still a lot of value there to protect his 50. But if your property's worth 100 and you want a $75,000 loan, then you're taking the first mortgage holder from being a fully secured creditor to now 25 of his 50 is unprotected, and that's going to be a problem. So you'd have to, yeah, a lot of this is negotiation. A lot of this you'll have to, uh, you know, argue in court in terms of valuation. It's another thing that you sometimes do pre-petition is you get appraisers in to sort of value what your inventory and other properties worth. Um, so you can see why this is complicated. And you need lots of professional advice. Um, Utilities, as we said before, they can't stop service because you owe them money pre-petition, but within 20 days after you file your bankruptcy, you have to give them uh, either cash deposit, a letter of credit, or some other security, or they don't have to keep providing it to you. So you have to have a negotiation with them. They may come in and say, I want 3 months security. You may say, I'll give you a month's security. And you'll have to negotiate that out so that the utility doesn't get stuck for whatever it's owed after you file the bankruptcy. Um, then, as we say, one way people raise money is to sell assets. If you have uh, uh, a piece of machinery that you no longer need and you want to sell it, whether it be trade in and replace it or just sell it to raise cash, you're going to need court approval. The only time you won't need court approval is if you're selling in the ordinary course. So if you're, let's see who's gone out of business lately, Bed Bath and Beyond, they can continue to sell their Bed Bath and Beyond inventory in the ordinary course of business. But if they decided they wanted to sell it in bulk to Macy's, they would have to go to court and get approval for that bulk sale because that's not ordinary course. So, um, and then there's also protection for consumers. I mean, if you ever go online and give your personal information, there's usually something that says, our privacy policy is we won't sell your information or transfer it or give it to anybody else. In bankruptcy court, the customer lists and customer information can be transferred, but there's a whole series of protections built in for the customers, and the customers can come in and object to that. So other than court approval, there's usually what's called an ombudsman's appointed to come in and look at the sale and the terms of sale and how the customers would be protected in the future. So again, the answer is you can't run your business like you would if you weren't in court. We've talked about financing, unsecured credit with administrative priority. That basically means that the lender would get paid before your unsecured creditors uh, who were owed money at the time you filed bankruptcy, and they could get paid before certain other claims in the bankruptcy, such as if you run up bills in the bankruptcy for purchase of goods, the lender could still get paid in front of them without a lien. Most lenders, I find, want security. So that's why we talked about before junior lien on unencumbered assets, a priming or co-equal lien on other assets that are liened, and so on and so forth. So I talked before about if you're going to um, take a lien with priority over somebody who has a lien, or the person has the $10,000 in the bank account and they need protection so they're not worse position, that's called adequate protection in the bankruptcy code. That's the legal term. And so how do you adequately protect somebody? You can make payments to them, periodic payments. For instance, if you have a car and the car has a lien on it that you use to finance the car, that lien holder is going to come in and say, every day you use the car, the value depreciates. And so I need protection. And so the court could say, and you could agree, all right, I'm going to continue my monthly payments to you. or uh, work out some other payment schedule that helps them maintain the value of their collateral and their position. So that's one way you protect them, is by making payments to them, so that the balance between the amount they're owed and the value of the collateral is maintained. You can give them a post-petition lien. So you could say to them, you know what, Mr. Car Dealer, I can't pay you, but I'm going to give you a second mortgage on my real estate, and it's worth a lot of value. And so you're going to be protected, because if you have a $25,000 car loan and I got 100,000 of equity in my real estate, if the car gets totally damaged or destroyed, you're still protected. So you can give them a post-petition lien on assets that it didn't have a lien on before the bankruptcy. And then there's a term called indubitable equivalent, which basically is anything else that you and they can agree upon is protection for them. People, you could give a personal guarantee. That could be the equivalent, which I don't recommend, but you could do that. You could go out and have your bank give them a letter of credit to support the claim. You could, come up with, you know, anything else. For example, if your lender has a lien on your receivables, now obviously the receivables are going to come in after the bankruptcy. You're going to collect them and use the cash, but you're going to be creating new receivables. So you could say to them, okay, I'll give you a lien on my new receivables after the bankruptcy. And this is it's technical, but it's an important point. When the lender has a lien on assets, that lien attaches to what you own at the bankruptcy. So, when I was dealing with retailers, they had receivables. The receivables they created after the bankruptcy weren't subject to the lender's lien. There were arguments they were, but basically they weren't. And so you had to give the lender a lien on your new receivables. Similarly with the inventory, you had a bunch of stuff in your store at the time of the bankruptcy. You sold it and you bought new inventory. That lender would not have a following lien on that new inventory. Now, as a practical matter, I think in 99.9% of the cases, we gave the lender a lien on the receivables and inventory that we acquired after the bankruptcy. But that is something else that you could do. And anything else you can do that sort of makes the lender happy, probably can get approved by the court. Now, um, talking about leases, um, as I said, if your lease has been terminated, you've got nothing to protect in bankruptcy because it's gone. But if it's not terminated and you're just in arrears, you just need to continue to pay the current monthly rent in the bankruptcy. And, part of the question is, that has been litigated often, is if you file on the 15th of the month and the rent was due on the 1st of the month, do you have to pay for the whole month, or do you just have to pay for the last 15 days of the month? And that's going to vary court to court. But in the bankruptcy, you just have to continue to pay rent monthly. And then you need to decide, do I want to keep this lease or do I want to get out of this lease? So, for example, sure you've read that many of these large national retailers are filing bankruptcy and closing stores. And so let's say that they have, for ease, they have a store in every state, but their stores in Idaho and Montana aren't doing anything except producing losses. So they could say, I want to terminate that lease, and they can do that in the bankruptcy. Let's assume that the New York and Boston stores are doing lights out. At some point in time, they have to say to the landlord in the court, I want to keep that lease in effect even during the bankruptcy and after the bankruptcy. So if you want to keep it in effect, it's called an assumption. If you want to get rid of it, it's called rejection. And so you have to file within 120 days after filing your bankruptcy to let everybody know that you're going to either keep the lease in effect or terminate it. Now, In large bankruptcies like the national retailers I'm talking about, they didn't make all those decisions in 120 days, so they always asked the court for an extension, um, and they oftentimes got it. Um, but there is a time period. And then for other executory contracts, and let's talk about what an executory contract is. Let's assume that you have a contract in which you've agreed that you're going to buy certain inventory from a manufacturer, and you're going to buy, you know, for a year, you're going to buy 10 pieces a month. Well, you haven't fully performed the contract, neither has the manufacturer. So you could say, that's a burdensome contract. I want to reject it, just as I do for my leases. Um, or you could say, I like the contract, I'm going to perform under it, and so on and so forth. And so for the other contracts that are quote executory, the court will usually set a time because the manufacturer will come in and say, I want to know, is this company going to keep the contract? Or they're going to get rid of the contract because I have a manufacturing process I have to go through and timing. And the court will say basically to the company, all right, you're going to let this guy know within X number of days. But uh, the premise is the same. You can either say, I'm going to accept the contract or I'm going to not accept the contract. Now, if you accept the contract, you have to cure the defaults. So in the landlord case, if you were 3 months behind, you'd have to pay the landlord the 3 months rent in order to accept the contract. He'd have to be brought whole. And then he'd have to be assured that you could continue to perform the contract for the rest of the lease term. So how do you do that? You do that usually by showing financial projections that you're going to be able to continue to pay your debts as they come due. Uh, and there are other things you can do too. You could give them guarantees, you can give them letters of credit, but generally what you did is you show financial projections to say, here's my financial projections. Uh, I can continue to make payments and still make my business go. So, but if you assume the contract, you do have to cure all the defaults. Um, Shopping center leases are a little different animal. There are a few more uh, items that you have to provide. For instance, if you're in a shopping center and you're CVS, uh, and you want to assume that lease, and they say, you know, um, you can't be in the business of selling whatever that was in your lease. You have to abide by any restrictions in the lease. You can't avoid all the restrictions, but um, if you're in a shopping center, there are some additional provisions. Um, okay. Now, I've been talking so far as if you're the tenant. What if you're the landlord and you file bankruptcy and you say, this lease is below market, I want out of it. So you reject the lease. The tenant can continue to occupy the premises and has to pay you rent. And if you were supposed to provide heat and air conditioning and you as the landlord don't do that, the tenant can provide it himself and deduct that from the rent. So you can't necessarily throw the tenant out automatically if you're the landlord. Uh, you can think about how that would impact the tenants if you could just do that. But um, so that's a protection for the tenants there if the landlords do that. Um, Other things that you can do in bankruptcy, can be done in bankruptcy. You don't necessarily want to do them, but your creditors may want you to do them. Preferences. The concept of bankruptcy is that everybody is going to be treated in the same fashion, so that no one's going to get preferred. So if you think you're filing bankruptcy and you owe your cousin Bob $50,000 and you save up before the bankruptcy, give Bob the $50,000 and the other creditors aren't being paid, then Bob's received preferential treatment. And the court does not want to see anybody receive preferential treatment. So if you owe money on antecedent debt and you make a payment on it within 90 days prior to the bankruptcy, and it allows the person receiving payment to get more than it would if it didn't get paid until the bankruptcy, the person receiving that payment has to disgorge it and pay it back so it is there for all the creditors. Um, there are, and if you make it to an insider would be an officer, a director, or an owner. So if you had loaned the company, $25,000 to make it through a tough time, and you paid yourself back the 25,000, the look back period is a year, not 90 days. Um, Now, there are exceptions to this if you can show that the payment was made in the ordinary course of business. And there have been, uh, you know, disputes about whether it's the ordinary course of business. So if you get 30-day terms from a vendor and you pay within 30 days, that to me is ordinary course business, and the vendor shouldn't have to give it back. But if you haven't paid the vendor for 90 days and then you give them a partial payment or a full payment within the 90 days, that's not really ordinary course, because ordinary course is to pay monthly. And there are other exceptions as well. But basically, you have to remember that anybody that you pay within 90 days on account of an old bill, not a contemporaneous exchange of value, shall we say, may have to pay that money back to the estate, so it's available for all creditors, and then there'll be a creditor in the amount of the payback. Um, that's something that all of these powers are powers that the creditors who are out money like to exercise, because they like to bring as much money back into the estate as they can. If anybody remembers the Madoff bankruptcy, one of the things that the trustee in that bankruptcy did is he went out to the people who had received distributions from Madoff and clawed them back and got them back in so that everybody could share in them, including the attorney, of course, who was getting them back. But fraudulent transfers is another way that they bring money back into the estate, and that is anything you transfer for less than a reasonably equivalent value. So that um, if you own your house, well, we're talking business. If you own a piece of real estate that your business operates from, or that you just own the real estate, and you say, listen, this real estate, I don't want to lose it to my creditors, so you sell it for $1 to your nephew. Well, the nephew isn't paying the fair value of the real estate, so the court is going to set aside that transfer and bring the real estate back in so that all creditors can participate in sharing in the equity value. The alternative at that point for your nephew would be to pay the difference between what it's worth and what he paid, uh, and he could keep the ownership of it. But once again, the purpose of this is that all creditors should be treated the same way, and nobody should be able to get a leg up on anybody else by either getting a payment or getting property transfer of them for less than fair value. Um, Also, some of you may have a bank account, or you may have an account payable to a vendor, and the vendor owes you money, uh, or you owe the bank money, and so they just do an offset. So the vendor says, I owe you $20, you owe me $50. All right, we're wiping out my debt to you, and you now owe me 30. Or the bank says, you owe me $10,000, you have $1,000 in your bank account, I'm going to take the $1,000, you now owe me 9,000. To the extent that the bank or the vendor shortfall improved as a result of that settlement, they're going to have to give that money back. So, let's just use the bank example. The bank's owed 10,000, it takes 1,000. So now, rather than being out 10,000, the bank's out 9,000. It's improved its position. But and once again, it's a 90-day test, so you keep looking back. But the bank, it may not be an issue if the bank has a lien on a piece of real estate that's worth $10,000. The bank won't have improved its position because it was fully secured before, and it's still fully secured. It's just they get a pay down of 1,000. But to the extent that somebody's put in a better position than they were within the 90 days, they're going to look the creditors are going to look to these people paying that back into the company so everybody can share on it. So you can see these are pretty powerful provisions that could impact you as the company or the principal of the company or people who are receiving transfers from you, because obviously during a time of financial need, you may make deals with creditors and say, I'll pay you for the current shipment and I'll give you $10 to the old shipment throughout. Well, the $10 to the old shipment throughout may be preferential as to other creditors. And so something to think about. Excuse me. So chapter 11 is the chapter that you would form a plan of reorganization under to reorganize your business and to come out of bankruptcy. There are a lot of hurdles and jumps to go through. Congress has enacted a small business case law, which it didn't have when I was practicing. And if you have less than $2.725 million as debt, then you can elect to use the less onerous provisions of the small business cases. Otherwise, you have to comply with all of the provisions of Chapter 11. Now, notable differences. Excuse me. Usually 7 of the largest unsecured creditors represent the class of unsecured creditors. They'll hire attorneys, they'll hire accountants, they'll be in court for every hearing, and in addition to getting the judge to go along, you either have to get them to go along or the judge to overrule their objections. And not only is that a problem in terms of administering your case, but you pay for the creditors committee's professionals. So it's more cash coming out of you. In a small business case, there's no creditors committee. There's no other professionals to pay who represent creditors. And so that is a benefit if you're a small business. Also, in a normal Chapter 11 case, a trustee or examiner can be appointed to investigate business operations. So if somebody thinks that something improper went along, they could ask the court to appoint an examiner to investigate the situation. And if they think fraud's going on, they can appoint a trustee, ask the court to appoint a trustee who would then come in and run the business. Normally, in a Chapter 11, you get to run your business, but in circumstances where there's fraud and other designated circumstances, somebody else can be appointed by the court to come in and run the business. In a small business case, that can't happen. They have a more of a limited role, and you're more running your business. Then there are time limits. You can't stay in Chapter 11 forever, even though some cases I was involved in, it seemed like the company stayed in Chapter 11 forever. But the debtor has the exclusive right for 120 days to file a plan of reorganization. So for the first 120 days, the company is the only person can say, this is how I want to restructure. I'm going to pay my mortgage lender according to the terms of the mortgage. I'm going to give my unsecured creditors 10 cents on the dollar in full satisfaction of their debt. And, this is what the company is going to look like afterwards. You have that exclusive right for 120 days. After 120 days, creditors and other parties in interest can file. So, for example, if you don't do it in 120 days, the creditors could file a plan that says, we're going to hire XYZ auction company, and they're going to auction off all the assets, close down the business, and we're just going to take the cash and distribute it. May not be what you want, but they have the right to do that. So you need to file within 120 days. And that time period can be extended. So when I said some of them seemed like they were in forever, it's because they kept getting extension over extension over extension. In a small business case, though, you have to do it within 90 days. They're saying you're not so complicated. You're a small business. 90 days, you have to file a plan. Okay. When you file, why did that come up? When you file a plan, in a normal case, you have to put together a disclosure statement, which talks not only about what the plan is, but it gives a history of your business, history of your financials, and so on and so forth. It's sort of like if you ever buy stocks in an IPO or of a public company, they're always filing SEC reports that basically give the whole history. It talks about the risks and the rewards and what could go wrong, what can't go wrong, who the officers and directors are, what their backgrounds are, why your business got into this bankruptcy, how you're solving it, why it's not going to happen again. It's usually a lengthy document, can be well over 100 pages. And that's so the creditors can make an informed decision on whether to approve your proposed reorganization. And both the disclosure statement and the plan have to be approved by the court. In a small business case, you don't have to go through all that disclosure. They're saying, once again, you're a small business, less than $2.8 million of debt. You don't have to jump through all those hoops. So then in a normal case, not a small business case, um, you need to, set forth how people are going to be paid. And the small business case, and there's a whole series of things that have to be in the plan. The small business case, they cut that back to include your history, liquidation analysis, meaning if we don't let the business continue when you just sold everything off, what will we get? Projections showing ability to make planned payments, you'll need that in both. And your agreement to give whatever earnings you have to the bankruptcy trustee so he can make payments in accordance with the plan. So it's much smaller plan of reorganization and much less detail than you would have to do with a full plan of reorganization if you weren't a small business. Now, how do you get the plan approved? Not only do you need court approval, you need one class of impaired claims. What's an impaired claim? An unsecured creditor is owed $100 and you're telling him you're going to pay him 10 cents to satisfy his claim. That's an impaired claim. A mortgage holder is owed $100,000 on your $300,000 building, and you say, I'm just going to pay you in accordance with its terms. They're not impaired. They're getting what they bargained for. So you need one class of impaired claims to say, I'll go along with this plan. And you can classify classes however is reasonable. People can object to the classification, but you can, sometimes you object and say one class of impaired claims would be not just creditors who I owe money for inventory, but one class would be landlords. One class could be stockholders who are owed money. I mean, you can classify them. As I said, classification can be objected to, but you can find a way usually to find an impaired class that will go along. Then the court has to find that the confirmation is not likely to be followed by liquidation or further reorganization. So, you're going to need somebody to prepare projections showing that you're going to be able to make it and comply with all of your future operational obligations, as well as making payments under the plan. And that's going to usually a testimony of a financial expert that comes in with projections. You need each class of creditors to accept by 2/3 in amount and half in number. So let's assume you put all your unsecured creditors together and they're owed $100,000. So, and there are, say, 50 creditors that make up that $100,000. So you need at least 25 of them to agree, and they'd have to represent $66,667 of claims. And so that's what you need in the normal course. And you have to pay administrative expenses at confirmation. Administrative expenses would be your attorneys, your accountants, the attorneys and accountants for the creditors committee, da 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 da. And you have to pay your taxes that you owe pre-petition over 5 years. Now, if you can't meet those conditions, the court can still approve it if it does a cram down. And there are lots of rules in cram down, which are probably too detailed to go through on this call. But basically, cram down is if you're a secured creditor, you get paid before an unsecured creditor. If you're an unsecured creditor, you get paid before the stockholders get anything. And that's sort of absolute priority: secured, unsecured, uh, and the administrative, the claims in the bankruptcy get paid before the unsecureds too. But uh, a court can do it, and it's usually is a fight, and you usually have to put evidence on. In a small business case, you can pay the administrative claims over time rather than paying them at closing, and the court can approve it if the plan's fair and equitable, meaning that basically all of your earnings over the next 3 to 5 years are going to make plan payments, and it's reasonably likely that you won't make those payments. Another thing about absolute priority is in a small bankruptcy, you as the owner can keep ownership. In a non-small bankruptcy case, you often can't keep ownership unless everybody in front of you is paid in full. So it'll be the secured creditors, the administrative creditors, the unsecured creditors. So in a lot of cases, what happens is that you, as the owner of the company, put some more money into the company so that you can retain your ownership. Unless you can negotiate that you don't have to do that. But if creditors object, they can say, you're not entitled to retain your ownership unless you either put some more money in or unless you satisfy us and get us paid in full or otherwise satisfy us. So you don't always retain your ownership interest in a bankruptcy. Some of the larger cases, you'll see that the banks and the creditors have taken over ownership. That's because the owners didn't put more money in, didn't add some more value to retain their ownership. Other differences, in a small business case, you have to file your latest tax return, balance sheet and cash flow, uh, maintain insurance and attend meetings with creditors. That's probably true in a large case too. You need to do all those things. But the concept was that there should be less burden on a small business than there is in a larger business. And that's what Congress was trying to achieve. Um, okay. That was all chapter 7, chapter 11, when you're trying to reorganize. Uh, chapter 7 is a liquidation. So you're not involved. You file the bankruptcy. The court appoints a trustee who liquidates the assets, investigates the debtor, and by investigating the debtor, they look for preference payments, fraudulent conveyances, any other ways they can get money back into the company. Um, and then they distribute the proceeds. And you still have to file your schedules with all your assets and liabilities and a statement of affairs. And you're going to have to go to meetings with the creditors in which they can ask you questions and the like. Um, some cases, the trustee can be authorized to operate the business for a short period of time. Generally, they just shut it down and liquidate the assets and then bring all the lawsuits they can to get money back from people that may have been improperly paid. Um, once again, as I said at the beginning, filing a bankruptcy is costly. You lose control, but if you're doing a liquidation, you can oftentimes do a liquidation outside of bankruptcy. When can't you? Well, if the landlord says, I'm going to evict you next week, you may need to file a bankruptcy so the trustee can use those premises because you've got a lot of inventory there and you don't want to have to move it out. So there are reasons to file a bankruptcy to liquidate. Um, but you can also do it outside of bankruptcy if possible. So Teresa, we're at 12:55. I know this is supposed to go an hour. Are there any questions?
We do have a question. When you mentioned the lien on the business residence, is your home safe from the effects of a business bankruptcy?
Um, okay. If if you haven't guaranteed the bank debt or the creditor's debt, then your home should not be involved. If you've guaranteed it, Massachusetts has a homestead protection, which protects up to a certain value of your house. But if you've given a mortgage to a bank to secure your business debt, that mortgage probably says that you waive the homestead exception so the bank could step in front of it. But basically, otherwise, you can have homestead protection. It won't, if you have a $6 million house and you're not going to be able to protect all $6 million, but I'm not sure what the current, it used to be like $500,000 of value could be protected from creditors' claims. I'm not sure that's the current number. I'd have to double check, but um, that is it's potentially protected from creditors. If you haven't signed any guarantees of the lease, of your creditor, of your business debts, or anything else, then your home should not be able to be uh, claimed by creditors.
Okay. I have another question, but I'm just going to say this first. If folks on the call, if you want to put a question into chat, just make sure it's addressed to hosts and panelists. If you don't want other people to see, your name with the question. But what about EDIL loans with no personal guarantee?
Right? Or what
This is
about,
this.
I'm not
This
sure
is
what the
this.
question is. The no personal guarantee, your personal assets
This.
will be
I
protected.
I apologize. That's the same person that asked the question about
Yeah.
the home.
If you have an EIDL loan and you haven't guaranteed the EDIL loan, the EDIL probably has a lien on your assets and they'll be treated as a secured creditor in bankruptcy. And you can either make a deal to keep paying them through the company, not personally. Company can keep paying them, or the company can give them another lien on something else they don't have. But they'd be just like a lender. They could either agree to sit back in the bankruptcy uh, or try to get the court to allow them to move forward to foreclose.
Um, Beyond this webinar, are there any recommended books or texts that you would that they could research?
Um, Let me think about that. I know of some legal texts, but I think we're looking for something that a business person could be more attuned to. There is something, I just can't recall the name of it. Let me look and I'll send it to you,
Okay.
Teresa, and then you can post it.
Yep, I have the person's name. We can do that. Okay, what about unpaid wages? How do they rank in the debt stack?
Okay. Um, Assuming you don't get court authority to pay your pre-petition wages, and there will be a limit on that, even if the court authorizes it. But where they stand is they are deemed an administrative claim, and they're allowed preference up to a certain dollar amount. I'd have to look to see what the dollar amount is now. It used to be like $3,000, and it's probably more. But if the company were to be liquidated after the secured creditor got paid, the pre-petition employee who's owed wages would have priority over many of the claims in the bankruptcy up to a $3,000 threshold. There's a whole uh, list of priority claims, and pre-petition wages up to a cap are included as a priority claim.
Okay, I don't see any other questions. Certainly, if anyone thinks of anything after the fact, please go ahead and reach out to me. I want to put my email in here and I can make sure I get a message to somebody for you. Here's my email. If you think of any more questions, please go ahead and send that to me and I will do my best to make sure you get an answer. Thanks, David. I did have another question about the information today. I will send out the slides as a handout and a copy of the recording. And again, the recording will be posted on the website in the next 24 to 48 hours. So that you can find it there at the score.org/Boston website under local workshops previously recorded. So, okay. Thank you, everyone.